Good morning. Are you Carrie Altz?
Yes.
And will your client waive the formal reading of the indictment and the motions in each case?
Oh, yeah.
Ms. Altz, in cause number 26 DCCR 0361. Oh, hold on. Wrong here. Should we get 26 DCCR 0319? Getting there. You're charged with the second-degree felony offense of robbery from January 13th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet in that case some documents that have your signature on them, but the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Your Honor, just for the record, just so for the court's information, this offer in this case reflects the fact that the robbery, as it's charged, involved an assault of a loss prevention officer at HEB on the way out of the store. Just wanted the court to know. I mean, the offense robbery, implies
correct
a certain thing in one's mind. Just wanted to let you know the underlying nature of the offense.
Got it. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Altz is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of robbery. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 20-35024, I have a motion to revoke your community supervision. Shows that you were placed on probation January 11th of 2021 for the offense of theft of property, a state jail felony. And that was a 2-year term that was probated for 5 years. Is that correct?
Yes, sir.
And then in cause number 20-35025, I also have a motion to revoke your community supervision. This shows you were placed on probation the same date, January 11th of 2021, for theft of property with previous convictions. And that was also a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Yes,
each of these cases allege that you violated your probation. And in count 1, in each case, it alleges that you failed to report as directed to the probation department since March of 2021. Is that correct?
January. When she next to confession.
Let me look at this. I'm just trying to go back and look at the PSI real quick from the original case, if it's in here. I don't know if it's going to be. Mm-hmm.
It might be one if it's a state jail.
Well, if it was a straight back then, I'm assuming that's because there was some criminal history. And I'm wanting to know what that criminal history is before I go along with the 21 months. Because if she went to probation for 2 months and we haven't seen her since, and she committed another offense that ended up being a robbery, then I think that 2-year sentence that she agreed to back then is probably what needs to happen on these 2 cases. I've already gone along with the other one, but I think, if either of you have that information.
I don't.
As far as her criminal history, I do,
Uh-huh.
Judge. I've got a summary of it here. I'll have to share it with you and Mr. Parker.
Theft in 2013, theft in 2015, theft in 2016, another theft in 2016, theft in 2017, criminal trespass in 2017, a theft in 2018, a theft in 2019, a theft in 2021, the 2 thefts from 2021. And now we have the robbery. You guys,
If I can just say this, Judge, I mean, like the robbery, it's been, I don't know about all the thefts, but the theft, like robbery, she took $18 for this stuff. It was feminine products and
at some time she's got to
I
stop.
understand about
And if someone's trying to stop you, you don't do what you did to that person by pushing them and physically assaulting them in other ways. So I just feel like we're rewarding continued bad behavior on these motions. And so really, if she wants to withdraw her pleas of true, we can have a hearing. Otherwise, punishment's up to me.
She'll agree to the 24 months, Judge. That was the original plea.
Okay.
Yeah.
Yeah, I mean, she agreed to it already back in 2021 and then
Right.
ignored us for the last 5 years and committed a new offense.
Yeah.
So with everyone's permission then, if it's agreed, I'm going to make that change on the agreed punishment recommendation sheet on each of these cases.
Objection, Judge.
No objection.
Okay, so let's go back then. Count 1, Ms. Alt, in each of these cases alleges that you failed to report as directed since March of 2021 in each of the cases. Is that true or not true? True.
True.
Count 2 in each case alleges that you provided a urine sample January 27th of 21 that tested positive for methadone, which you had a prescription, and opiates. Is that true or not true? Count 3 in each case alleges that you failed to perform the community service hours as required. Is that true or not true? Count 4 in each case alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
True.
And then count 5 in each case alleges, obviously, that you are behind in your court assessed fees. Is that true or not true? Do you enter your pleas of true to counts 1 through 5 in each case freely and voluntarily? And because you actually, those violations are true. In each of those cases, I have here on the tablet documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over these with Mr. Parker?
Yes.
And do you fully understand them as well?
Yes.
And you understand if I follow these agreements, which it's my understanding now that you have agreed to that original sentence of 24 months, is that correct?
Yes.
That you'll be waiving any right to appeal?
Yes.
State tenders number 1 in each of those cases.
No objection.
It's admitted in each case. Is there any, no evidence, of course, that she's not competent?
No, you're
Right, ma'am. In each of these cases, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. In cause number 20-35024, find sufficient evidence to revoke your probation, and at this time, revoke your probation and sentence you to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 20-35025, also find sufficient evidence to revoke your probation, and at this time, revoke your probation, sentence you in accordance with your agreement to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 3 cases will run concurrently, which means together at the same time. And I'm going to hand you in all 3 cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Obviously, Ms. Alt, you've got a lot going on. It sounds like there's probably drug issues. I don't know exactly what's causing all this, but you're going to have an opportunity while you're in prison to get help. They're not going to make you do it. But if you choose to do it, you can get out and you can learn how to quit stealing and quit doing what you're doing so that you can live out like the rest of us. All right? Good luck to you.
Thanks, Judge.
Thank you. Okay, you're Floyd Torin. And this is cause numbers 25 DCCR 0974 and 25 DCCR 1152. Mr. Torin was previously in court, entered pleas of guilty to attempt to commit theft of property. It was enhanced to a second degree because of priors, and then evading arrest or detention with the vehicle, also enhanced to a second degree. I've received the pre-sentence report, and the agreement was for a cap of 20 years. It looks like it probably could have been habitual, but you guys pled it to just a straight second degree with an open plea to the second, correct?
Yes, ma'am.
And I've received the pre-sentence report as well as some documents that Mr. Radford has sent in with regard to Mr. Torin's mental health, as well as some physical issues, and one letter as well of support. Have you both had an opportunity to review all of that?
Yes, ma'am.
Yes, Judge.
Are there any additions or corrections to that pre-sentence report?
Just the things that I submitted, Judge.
Okay, Mr. Radford, you may proceed.
Judge, Mr. Torin has an extensive criminal history. However, as he has gotten older, he has had some health issues. He has vision problems. He has been seen and treated at Spindletop MHMR for some mental health issues. He has a very supportive family who is here today, and I'd ask that the court take that into consideration in determining his sentence.
What is the status of parole?
No, we're waiting on the way. Okay.
Mr. Smith?
Judge, his extensive criminal history going all the way back to his juvenile years tends to show more about what he is and what he does than anything else. He's been given probation. He wasn't able to complete that. He has been sentenced to multiple long sentences in prison, and that seems to be the only thing that has kept him from committing new crimes in society, was the fact that he was incarcerated. I don't feel like probation is appropriate. We would ask for, we have given him consideration by coming off of the habitual and capped this at 20 years. So we would ask for a TDC sentence in the high range on this.
So, Mr. Torin, in 2019, you received a 15-year sentence. So you were only not, I don't know how long it doesn't show me when you got out or how long you were in on that, but obviously.
I got out one night of 23.
So you got out in 2023, and less than 2 years later, you've got two more felonies, which add up to your 11th and 12th felony offense. And I understand the issues with PCP. It looks to me like that's more of an issue than anything else. I understand there's some mental health issues, but you, as a grown man, have had every opportunity to get help and try to get in TDC, out of TDC, to live your life outside of prison, and you've chosen not to do that. I mean, your only time clean is when you're in custody. That's what you told the person doing that substance abuse assessment. I don't know. I just think it's I appreciate your family being here and I appreciate the support and I appreciate this letter, but it's all ridiculous when you look at your criminal history and the fact that you're on parole and you commit 2 more offenses and you're still using drugs and you haven't it's not like you're a young kid. You know what you need to do to get the help you need to get. And you've made a conscious decision not to do that. So at this time, in cause number 25 DCCR 0794, and this evading was crazy. I mean, you could have killed people. You got used, I think it was twice you almost struck intersection of Interstate 10 and 7th Street, almost struck another vehicle. And then again at 7th Street and Dollinger, you almost struck another vehicle. You crashed through a fence. Then you continued to flee after you crashed through a fence and crashed again and finally came to arrest. I mean, it's not like you just kind of sort of evaded. Your behavior is just a danger to everybody here in Jefferson County. So that being said, 25 DCCR 0794, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of an attempt to commit theft of property, find that prior conviction true, or the prior convictions true in that case, sentence you to a term of 20 years in the institutional division of the Texas Department of Corrections. In cause number 25 DCCR 1152, find also sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true, sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Correction. You will receive credit on each of these sentences for any time that you've been in custody that the law gives you the right to receive. I'm handing you, and they will run concurrently, which means together at the same time. I've handed you the trial court certification that shows these were agreements. I followed. You've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. Read that. You should already understand it. But if you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Radford. All right, you can go back with the bailiff. Yes, sir. Good morning, sir. Are you Desarian Adams? This is 23 DCCR 0492 and 0493.
TRP announcement.
On both cases, correct?
Yes, Your
What's the announcement?
Honor, they've made an offer, but we're going to need a hearing on this. We can't come to them.
Okay, so did we already go through the motion?
We did.
Did we start going through it and then stop? Because I didn't make any notations of pleads of true or not true. I don't think.
You didn't make any on this one either.
What we did was I'll read through to all the violations except the new allegations, which were the misdemeanors. And you said, no, we've got to do them all. So we stopped. There's 2 misdemeanors there. I think one's a shooting.
Okay, I mean, and I wouldn't have said, I mean, I guess as far as an agreement goes.
We will go on work, but did not.
He did plead true to counts 3, 4, 5, 6, and 8. And it was reset for an update.
Something happened and we stopped because I didn't make the notations and we didn't get it updated. So let's start back from scratch. We'll go through the motion, get pleas of true or not true, and then we'll reset it for a hearing. No, ma'am, I'll take care of it. There's 2. Yeah. The second one, please. Okay, so Mr. Adams, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. And will your client waive the formal reading of the motion in each case?
Well.
So, Mr. Adams, in cause number 23, DCCR 0492, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 26, 2023 for the third degree felony offense of deadly conduct, discharging a firearm. And that was a 5-year deferred probation. Is that correct? And then in cause number 23, DCCR 0493, I also have a motion to revoke your unadjudicated probation. This also shows you were placed on probation September 26th of 2023 for deadly conduct, and that was also a 5-year deferred probation. Is that correct? Both of these cases allege that you violated your probation. Count 1 in each case alleges that you committed the offense of fleeing a police officer December 6th of 2025. Is that true or not true? Count 2 in each case alleges that you committed the offense of unlawful carrying a weapon December 6th of 2025. And is that true or not true?
Not true.
Count 3 in each case alleges that you failed to avoid persons or places of disreputable or harmful character, and that on December 6th of 2025, the arresting officer stated that the vehicle operated by you and occupied by 2 passengers emitted the distinctive smell of burnt marijuana. Is that true or not true?
Not true.
Count 4 alleges that you failed to immediately report your arrest to the probation department. Is that true or not true?
That's true.
Count 5 alleges that you failed to provide verification of performing the community service hours as ordered in each case. Is that true or not true?
Yes, not true.
Okay. Count 6 alleges that you were at a location other than your residence at approximately 11:23 p.m. December 6th of 2025. And is that true or not true?
True.
Count 7 in each case alleges that you were in possession of a firearm by having 3 pistols located on the back driver's side seat, concealed under a black jacket in the vehicle that you were driving. Is that true or not true? And count 8 alleges that you're behind in your court assessed fees as of December 8th of 2025. In cause number 0493 in the amount of $540. And in cause number 0492 in the amount of $2,942. Is that true or not true? Okay. Did you enter your pleas of true in each case to counts 4, 6, and 8 freely and voluntarily? I'm sorry?
Yeah.
And did you plead true to those counts because they're actually true? All right, then I'm going to find those counts true, find that you entered your pleas freely and voluntarily, find sufficient evidence in each case to revoke your probations and find you guilty. But I am going to reset this case for a hearing. Do you anticipate, I guess, a little bit of time on this one with witnesses?
I think so, Judge.
Like,
The offenses,
I'm sorry.
an hour.
Okay. All right. So we'll get it set for a hearing. I'll get an updated pre-sentence report and
We'll have some.
okay, we'll do it on a different day than a docket day then. All right, you can go back with the bailiff.
Yes, sir.
Good morning, you're Larry Fitzgerald Williams, and this is cause number 25 DCCR 0985. And
This is the exact moment the judge makes it clear that rehabilitation is no longer outweighing public safety concerns. Legally, the court is sentencing a defendant with an extensive felony history who was already on parole when these new offenses occurred, including an evading case so dangerous the judge specifically describes vehicles nearly being struck during the pursuit. That matters because prior prison time, failed probation attempts, and repeated felony conduct all heavily influence sentencing decisions under Texas law. Emotionally, you can hear the frustration building as a judge acknowledges the support of the defendant's family while simultaneously pointing out that years of opportunities, treatment options, and prior incarceration have not stopped the cycle of criminal behavior. And here's the difficult question hanging over this courtroom. At what point does a judge stop believing that another...
And 24 DCCR 1790, Mr. Williams is charged with capital murder as well as aggravated assault causing serious bodily injury. And what is the announcement, Mr. Cashin?
We need to take care of some housekeeping matters because the last time we were here,
you'd order the state to provide us with written notice whether they're going to seek the death penalty. And yesterday afternoon when I left my office, I had gotten nothing from the state as to whether or not they're going to seek the death penalty. And I would like that information as soon as possible, in accordance with the order that you had.
Smith?
State's not seeking death penalty, Judge.
Okay, if you'll get that in writing to Mr. Cashin so he has it for his file. That way that gives him the opportunity to know how to move forward. I'd like to get this case, if it's going to be a trial, tried before the end of the year.
Yes.
And so I want to,
Agree.
And there are some other issues, Your Honor. Back when we first came to court, I had filed a motion to quash the indictment because the indictment, from what I understood, was incorrect because it was under a wrong provision and it was for retaliation against the judge. And they have not corrected that in that indictment.
just even, let me pull that.
Yes, ma'am.
So I think we discussed this, and it's only the heading, which is not substantive. Obviously, the substantive part of the indictment is what the actual charge is, which is the retaliation
Yes.
against Mr. Lewis. It's the indictment itself is not going to be quashed because of what's ultimately a typographical error in the top.
Okay.
I do think it's clean, or for the record, if you want to make an oral amendment, I think that's something we can do today.
Okay. Right from the state.
I think it needs to be correct as well. And it's not 18. I can't remember which one it is, but I'm gonna look. I know we had this conversation.
Yes, ma'am.
Do you remember which one it is by
In the
chance?
very beginning, well, I left that file in my office.
That's all right. I can figure it out. Let's see, 19. Go to. A.
Team. I mean, that is correct.
That is correct.
1900.
1903, 18 is correct.
It is.
I can look.
There was something that I do recall us having a conversation about, but
Well, it says murder for retaliation, judge, justice. I mean,
the
we can
judge
line
justice
through
needs
that.
to be interlineated, but the
Right,
section
that's-
number is actually
Okay,
correct.
that's what
That's the, okay.
that need to be delineated.
Any make an oral motion to
We would
do
make
that?
an oral motion to strike that from the.
Okay, and
Hold on, any objection to that?
no, Your Honor.
All right, give me just a second to get it done before I move on. It doesn't want to give me that option yet. Okay. That's weird. And we need to, would you, make a note on a ticket? For some reason, the one thing that I need, which is the interlineation thing, is not letting me do it. And it has in the past. Okay. So I'm just going to print it. Yes, and we'll do it that way. Okay, what else?
We recently got an email from Mr. Smith about some discovery, and I bought a 1 terabyte drive to be copied, the information that he's referring to.
Okay,
And so I would like that. Then I have a motion to change venue right here, but I need to get Mr. Williams to sign his affidavit, and it will be filed this morning.
okay. So with regard to discovery, y'all can take care of that.
Yes, ma'am.
I don't need to get involved in that. And And then, if something is filed, with regard to a change of venue, I'll get that set for a
Yes.
hearing within the next few weeks.
Yes.
Obviously, that's something we'll need to get taken care of so everybody can plan ahead
Yes, ma'am.
on what we're doing. So once it's filed, I'll
It'll be,
give everybody an opportunity to get ready and we'll get something set,
that'll
I
be
would
done.
say within 2 or 3 weeks.
Thank you, ma'am.
Okay, anything else?
That's it for now.
Okay, all right, if if you need him, to sign that in front of,
Notary?
if you can step over here in front of the clerk, she'll take care of that.
Thank you. Thank you, Judge.
Thank y'all. She's gonna go get her,
Notary.
notice. You're Bobby Clark? And this is cause number 25, DCCR 0802. Mr. Clark is charged with indecency with a child by sexual contact. And what is the announcement?
Judge, this was set to this court date for a status. I think Ms. French had ordered the CPS records.
Hold on a second. I need y'all to all hold it down, please. Go ahead.
Ms. French had, through the court, obtained CPS records. We both have copies of those.
Okay, good.
So I think at this point, we're needing to just set this back on the trial docket.
Okay.
There's already a rejection on bond.
Has there been any change in what the offer was? It looks like it was back in August of last year. There was a rejection of a 12-year term.
Correct, Judge. And I don't know what Ms. French intends to do, but I do know that she is planning to meet with the complainant soon.
Okay.
And we talked about that today. If there is a change, we would obviously bring that to the court's attention
Sure.
beforehand.
So let's go ahead and get it on a trial date.
Just because it goes the nature of the case, I think.
Yeah, for sure. All right, so Mr. Clark, I'll get your case set on the trial docket. If something changes with any negotiation, y'all just let me know as soon as that changes, then we'll get you back in here. Otherwise, we'll see you at the next on the first trial date. Okay. Trying to get back to the bailiff. Thank you. Good morning. Are you Logan Eaglin?
Yes, ma'am.
And I really need y'all to, if y'all are talking about a case, don't walk across each other, get closer. I'm having a hard time this morning for some reason. Mr. Eaglin, this is 25 DCCR 0897. You're charged with aggravated assault with a deadly weapon. Your case is set for trial to begin with jury selection next Monday. And what is the announcement?
Judge, this is a case that the state will dismiss because we're re-indicting as a murder. We found out that the victim died approximately 7 8 days after the assault.
Okay.
So it would be not tried as the aggravated assault, but tried as a murder.
When do you anticipate that indictment?
I think it will go tomorrow.
Okay, so obviously if that's going to happen, it doesn't change a lot of the discovery, I wouldn't think. And so we can go ahead and leave it on the trial docket.
Yes, ma'am.
Because you've already got everything. It just changes the nature of the offense, correct? All right, so, but I guess, if it's indicted tomorrow, it changes it enough to where if you need some time, you're entitled to that.
Yes, Your Honor, if we could have at least 30 days.
Yeah,
There will be at least an autopsy report and
so
pictures.
potentially some additional things for you to go over.
Evidence.
Okay, so what I'm going to do, Mr. Eaglin, is reset your case to the next trial docket, so that once Ms. Barrazo gets everything, any additional discovery, which it sounds like there's some more information coming because the case is going to be upgraded to a murder charge instead of the ag assault. We'll give her some time to go over all of that, go over all with you. If there's any new offers or plea negotiations, then let me know. If something changes before that trial date, we can get it taken care of.
Yes, ma'am.
Okay, you can go back with the bailiff. Email them to Mr. Smith as well.
Did you get the medical records, anything?
Did you sound better?
About 3 or 4 weeks ago.
Yes, I think I did. You emailed them.
I don't know, there was at least another email address. I know that it was home, so I wonder if it
By
was
the
the wrong.
end of this courtroom session, nearly every case on the docket reflected the same harsh reality. Repeated criminal behavior eventually reaches a breaking point inside the justice system. Some defendants accepted negotiated prison terms after violating probation, ignoring court conditions, or committing entirely new offenses while already under supervision. Others faced escalating consequences as prosecutors upgraded charges, pursued revocation hearings, or prepared cases for trial involving deadly weapons, firearm allegations, and even potential murder charges. Throughout the hearing, the judge repeatedly emphasized accountability, personal responsibility, and the danger posed when defendants continue reoffending despite prior opportunities for probation, treatment, or parole. The courtroom also highlighted how quickly criminal cases can
So I wonder
intensify.
if it went to the wrong person.
No,
Correct.
what day was it?
It's about, huh?
Spinal Tap stuff?
Yeah.
What day?
Can you tell what day he emailed it?
No, I don't think
This is
that is
just-
the email. It just.
It was about 3 or 4 weeks ago.
Can you look and see what the date was?
On my office, because I don't know if it's going to show on my phone.
All right, well, obviously I'm going to need a minute to go through all this. He can go back for a few minutes or have a seat.